Yes, Mr. Ball.
Well, I've trouble with what I've called a roadmap. This is partly for my protection.
It's been sent electronically.
Yes, I hope in a way that will be effective. The file name is Respondents Open. That shouldn't.
You sent it to my clerk.
I believe so. I've got a sent confirmation.
It hasn't gone.
Came right. There's another way to do it. Okay, this is getting a crash when I tried the other way. Would it be possible to make a start on the basis?
Yes, you make it. I'm not looking at the paper. I can't read it, Mr. Moorehead.
I understand. The first point in the purpose of the roadmap is to, it's partly for my own protection, to ensure that I've covered everything off, but it also calls attention to the parts of the skeleton argument that relate to each of just 5 propositions. And the first is our primary case, that the appeal should be dismissed because a correct analysis of the language in section 10.1 demonstrates a clear meaning. Even if that's not enough by itself to demonstrate this clearly, then the meaning becomes clear when combined with a correct understanding of the mischief which that section was intended to address. The second proposition is that even if you're against me in being satisfied that what I've just said emerges clearly, they do, at least I suggest, indicate uncertainty as to whether the meaning of section 10.1 includes a public right to erect tents, and in that event the appeal should still be dismissed for 3 reasons. First is the principle of interpretation against expropriation. Secondly, the principle of interpretation of a private act against the promoter. And thirdly, because of the rule in Pepper and Hart. Thirdly, and I hope you'll forgive me using this word iteratively, the second point. The material which is relevant to Pepper and Hart is also admissible to show that it is uncertain whether section 10.1 includes a public right to erect tents. The same material also resolves the uncertainty, again in our favour. The fourth proposition is that when analysed correctly, the matters relied on by the appellant and the OSS are at least consistent with or positively supportive of a meaning of section 10 which does not include a public right.
Sorry, you have to speak up a bit, Mr. Moorehead. Meaning consistent with?
A meaning consistent with or positively support a meaning of section 10.1 which does not include a public right to erect tents. And the fifth proposition, again, I may say so iteratively with the second. Alternatively, and in any event, the matters relied on by the appellant and the OSS do not demonstrate that the clear meaning of section 10.1 includes a right on the public to erect tents on the commons. And
so, are we using erect tents as a synonym for camping now?
Yes, I've heard the submissions that have been made, and I can see that there is a need to be more precise. Because our objection is to that form of camping which involves the erection of tents. That is the point.
So, can I just be clear about this? I think this is important. And I've just written down camping involving the erection of tents. Now, if in the very old days, a traditional hobo, you may not have heard the word for many times, an itinerant man or woman carrying just a small handkerchief full of belongings was to walk on the common land or the national park and want a rest and lie down with the pouch full of belongings by their side and sleep, would that be contrary to the right granted by Section 10?
I'll answer that in two stages, if I may. The first is probably that is not within the right granted, because sleeping is not recreation on any possible view. The second part of my answer is this. That, however, is not the focus of our case. I appreciate that a lot of submissions have been made about the meaning of recreation. Our submission is that that's really a slight sideshow. The question really is, what does the Act authorise in the way of presence on the commons?
Well, I was going to ask you the next question. So let's transform the hobo into a rambler of modern times, carrying a rucksack packed to the gunnels with tins of baked beans and other sustenance, but no tent. And this rambler becomes tired 5 miles from the public highway and chooses to lie down to rest. Doesn't sleep, but to rest and enjoy the air on the moor with the rucksack by their side. Is that within the right?
We will come to these points, but I'm happy to take them up front
But
now.
you can see where I'm going.
I can.
I want to know where the line is.
The line is drawn, we suggest, in the, I've suggested in paragraph 22 of the skeleton argument. Where I've said the OSS is wrong to compare erecting tents with rock climbing, eating picnics, taking refreshment during a long walk. When a walker or a rider pauses, for example, to eat a picnic or enjoy a view, that does not involve the walker or riding doing anything more than be on the commons. The word be, of course, is a reference back to what Section 10 says you can do. You can be on the commons. Because a person who is on the commons, eating food or stopping to enjoy a view, is not doing anything appreciable beyond being there. And this is the test I suggest now. Not that one can test is an overstatement. But the same is likely to be true of most activities which are, so to speak, internal to the near body space of a person on the commons, plus any horse he or she is riding. That is likely to be, if not the controlling, then a influential consideration. I'll return.
Okay, I get that. And so I would quite like you to explain, if you will, the answer to paragraph 78 of the judge's judgment, where it seems to me, importantly, he says in the second sentence, I consider that Mr. Morshead is right, that the phrase right of access to the commons on foot and on horseback for the purposes of open-air recreation is the statutory formula which is being used to describe the right to roam on the commons.
I'll do that in 3 sentences.
Where does that come from?
The language in Section 10 is borrowed from Section 60 of the 1949 Act.
Sorry, the language of section 10.
is borrowed from section 60 of the 1949 Act.
Yes.
Section 60 was stimulated by the footpaths report in 1947. I can show you all this in a moment, just so you have it in these three sentences. The third sentence is, the footpath report deals only and exclusively and explicitly with railing.
Report of 1947. And that deals with the right to roam.
That deals with the right to roam. Now, there was no answer to any of this. It's in my skeleton argument, but there's been no answer to any of this. What the appellant has done is muddle up the footpath report, which is the foundation for section 60, with the National Parks report, which was the foundation for earlier parts in the 1949. Now, the Parks report is replete with references to camping. I'm going to show you some. But it's got nothing to do, literally nothing to do with section 60. That's where the judge got and he's abbreviating, but that in three sentences is the basis of the material.
The year of the Parks report.
I beg your pardon, my lord. The Parks report, I believe, is also 1947. These are the Hobhouse reports. There were three of them.
They're all three.
They're all three Hobhouse. Two of them are in the bundle. The Parks report is in the bundle. The Footpath report is in the bundle. There was another one. I think it was Nature Conservancy, which is not in the bundle.
Okay.
So that is my three sentence answer to your lordship's question. But if I may, I'd like now to return to my roadmap by seeking, if I may, to develop the point that I was on before lunch, which is to concentrate on the language itself in section 10. Because, of course, if I can't get what I say is the right interpretation out of section 10.1, then the appeal must be allowed. I'd shown your lordships, by way of contrast, the wording one might have expected to be used if section 10 had the effect for which the appellant contends. There isn't a right to use or occupy commons and so on. I drew attention to the use of the singular purpose. But reading on to what we're calling the second half of section 10.1, the first is an obvious point. It's the use of the word and. Just by way of emphasis, it's clear that the second half of section 10.1 is the corollary of the first. That is to say, there is symmetry between the right granted in the first part and the protection from trespass in the second part. The next point involves reading on just three words, and it's an important point, and a person. This is where I suggest really one starts to understand how this section works. What is immunised? Whatever the ambit of recreation may be, and this is why I say recreation is a bit of a side issue, whatever is authorised by the first part is at most a person, and of course a horse, but a person who enters on the commons for that purpose without breaking or damaging any wall, fence, hedge, gate or other thing, or who is on the commons for that purpose having so entered.
You have to emphasise so, don't you?
Exactly so. Yeah. Or incur any other liability by reason only of so entering or being on the commons. Again, there is consistency in the singularity of the purpose and what gets protected.
Sorry, since you're being very careful with the language, what do you say the word so brings in, both in the antepenultimate line and in the final line?
Entering on foot and on horseback for the purpose
Yes,
of
I see.
open air
Includes
recreation.
includes the purpose.
Yes, fully accept it includes the
Yep.
purpose. Yes, absolutely. But the emphatic point is that what gets protected is and is only being on. It is the presence on the commons of a person and or his horse. That is all. And one can understand why the draftsman used that language, rather than, for example, saying a right to go on and walk or ride a horse. As soon as you say walk, the question arises, what about runners?
No, the question arises if you're very interested in the single purpose, on what happens if a person enters on the moor with multiple purposes in mind. So, I mean, I guess that people enter on a walk with the purpose of looking at wildlife, looking at flowers, looking at birds, looking at the sky, enjoying the air, all those things,
Yes.
Perfectly uncontroversially, and many more.
Yes.
So why can not all those things be the purpose of open air recreation?
Well, possibly they can, but that doesn't meet the point that I'm now seeking to emphasise.
But all the second part of the section says is that a person who enters the commons or is on the commons
Yes.
for the purpose of open air recreation will not be regarded as a trespasser.
Yes.
So you don't have to specify a purpose, and any purpose will do, provided it's open air recreation.
Well, no, provided you are not yourself doing anything appreciably beyond being on the land.
But it doesn't say that, does it?
Well, it does say that.
It wouldn't make sense anyway, would it? Because suppose the purpose is something that involves you doing more than being. Suppose the purpose is to sit down with your sketchbook and do a cloudscape.
Yes.
Now that would be I would suggest being there with a purpose, but you are doing more than simply being on the land. You're sitting painting away. Maybe you even put up an easel.
I accept that depending on how narrowly one drills down into the language, one can reach that kind of point. My purpose in making this submission to your lordships is to indicate the frame of mind of the drafter, what was contemplated at the time and what is reflected in the language. Your lordship is absolutely right that an activity such as sitting down, I've given the example of taking a picnic as being within what is authorised by the Act. Drawing birds or a landscape would likewise be within the contemplation of the Act, I strongly suggest. Nevertheless, in that situation, the individual involved who is undertaking that activity is not doing anything appreciably more than be on the land for the recreational purpose. What the words achieve...
well, it's not really for a recreational purpose. We keep on using synonyms which are unhelpful. I mean, it is for the purpose of open air recreation.
Yes.
And my lord's example could be said not to be open air recreation at all. It's painting.
Yes.
Well, it could be done anywhere, but it's just you have to have the view.
That's why I didn't want to get too detailed in this question of what particular activity does and doesn't count as recreation. We can be here all day on that question. The question is, what is this language taken as a whole, and when examined with emphasis on the points I've drawn to the court's attention, telling you about what the right is that's conferred?
You see, what I'm troubled by, Mr. Morshead, personally, and I speak only for myself, is the judge's reasoning in the sentence that I drew to your attention, because that seems to me to be absolutely central to his decision. And he said that basically it was all about the right to roam. It was simply a statutory mechanism to describe the right to roam. And my question is, where does that come from, the language?
Well, if one recognises that the right conferred is access on foot and on horseback, and that nothing more is contemplated than presence. Obviously, there must be some margin of appreciation. There must be some. But the paradigm case being contemplated is just presence on the land. What is the activity being described there? The natural conclusion is that that is a description of an ambulatory process, a transient process. What you do when you are on foot or on horseback. That is what is getting authorised, and not more. And
Sorry. Can we just break it down a little? You say what you do when you're on foot or on horseback. Well, in that case, you can't stop at all. But obviously, you can.
We've accepted that that is achievable either under one of two routes. Either because one builds in a margin of appreciation to the question of what is meant by the word be or is in the second part of section 10.1, or alternatively because of the doctrine of ancillary uses.
Well, can we just think about the first of those a little bit more? The second part allows you to be on the land. Being is not ambulatory, it's stationary.
Well, but in the context of
Having entered on foot or on horseback.
And on horseback.
So you have to enter on foot or on horseback. That's ambulatory or horse ridery. But then it says it's all right if you're there. That's not ambulatory.
Your Lordship may well be right. It's not penalising you for having stopped once you're on the
Well,
common.
it says you can. It says you're not a trespasser if you stop, provided you entered on foot or on horseback.
Yes, and I'm accepting that, because that contains the margin of appreciation which enables a person to go on foot or on horseback, and stop for at least some kinds of activity.
But on the face of it, you don't need a margin of appreciation because it says you can be there. You don't need to say that's an extension of walking because it says if you've gone on foot or on horseback, you're allowed to be there.
Yes. Lords, I don't wish to push back too hard on that because I'm substantially agreeing with your Lordship, I think. My concern is that one starts to engage with a slightly different topic of controversy from the one which we see as being central to this case, which is what is a recreational activity, what counts as open-air recreation.
Can I just work there by stages for a moment? Then you focused on the fact that it's a person. So suppose you stop with an easel and do your painting. Is the easel all right, even though it's not a person?
Here we enter into the potential for grey zone. The way I have put it in the skeleton argument is this question. It's in this way. It's by the suggestion that a tent is not in that category. Whatever may be the case with articles which are close to a person and which occupy little beyond the body space of the person may well be within what is permissible under the Act. They may well be.
Well, I mean...
But a tent acquires a separate structure.
And a picnic spread may well take more room than a tent.
It doesn't acquire a separate... It's not a structure. It doesn't acquire a presence of its own on the land. If you walk away from a picnic, it's always going to be your picnic you've walked away from. If you walk away from a tent, it will not necessarily be your tent.
Oh, that I don't follow. Very subtle.
The tent has a presence of its own. It's a structure which has been put up.
So does the picnic rug and the...
I suppose your Lordship is right. But in the imagination that I'm using, the picnic is going to be something associated necessarily with the person who goes along to have the picnic. But a tent could be put up by person A for use by person B later, or person C after that.
So it's the structure you object to.
That's exactly the point. What is it that Section 10 says to indicate that it contemplates a structure being erected on the commons?
Just before you resume your general path, can I check one other thing? You say, well, the meaning of recreation doesn't really matter all that much, but Mr. Honey has quoted, I think, the Oxford English Dictionary, a recreation is an activity or pastime pursued for the pleasure or interest it gives. Now, do you disagree with that?
I have issues with that. It is very, I mean, I've heard it said,
it's
There
very
are some people
wide.
who enjoy their work. So there must be some limit on that. Exactly what the limit is not something that I suggest one needs to grapple with in this case, where the expression isn't even recreation.
And so to be clear, if we don't need to grapple with it, is that because wild camping is of itself apt to be regarded as a recreation and the restriction is to be found somewhere else?
I go back to the 2 points I made in answer to the Master of Rolls earlier. In point of detail, I say that sleeping overnight on the Commons is not recreation, open air or otherwise. It's just sleeping. But if I'm wrong about that...
Because you're asleep.
You're just asleep. But if I'm wrong about that, it doesn't matter for the purposes of the argument I'm seeking to address your lordships on, because that person has not done the thing of erecting a structure on the Commons. Whatever may be said about what is permissible under the rubric of recreation, it's something that has to be personal. It doesn't extend to putting anything up, to erecting.
So just to be clear, is this restriction to be found in the meaning of the word recreation, or is it to be found elsewhere?
The second of the restrictions I've just described is to be found in the second part of section 10, which immunises only the activities of a person. Whatever the breadth of those activities may be, nothing is contemplated in the way of erecting a structure such as a tent.
I don't know if this is a helpful observation or not, but it's occurred to me, as you rightly say, that the two halves of section 10.1, the second half is presented as the corollary of the first, and isn't really addition. It's not a word as used here to add a new point. It's really to spread out the consequences.
Yes.
But you could look at it the other way around. What is this really about? It's to see that someone isn't treated as a trespasser. They can't be turfed off. They can't be sued.
Yes.
And so really what this is aimed at is the thing that would be a trespass. And what would be a trespass would not be doing this or that. What would be a trespass would be mere presence. I think that probably helps your argument.
I think I agree with your lordship, subject to, well, I suppose with this additional point, which is that way of looking at it helps further to shed light on the conclusion that the judge reached in regarding that expression for the purpose of open-air recreation as descriptive of the jus spatiandum. Because that is the purpose.
As a description of
The right to wander.
the jus spatiendi.
Sorry.
What's the English?
You're pronouncing it, I would have thought, in
What's
the
the
correct old-fashioned
English?
chancery way.
What's the English?
The right to wander.
Right. Can we use the right to wander so that
Yes,
people
certainly.
Or
listening
even
to
Rome,
this
perhaps.
Right to Rome. Yes. Right to Rome. R-O-A-M.
You know, I heard. I just don't know if that's the correct pronunciation, the correct translation. But anyway, okay, we'll call it the right to.
It's to wander about. It was described that way by Lord Briggs in Regency Villas.
Regency Villas. Yes.
Case of painful men.
Regency Villas is not a case that is relevant in any way to this case, is it?
Except for explaining what that Latin expression means, but otherwise it's not relevant.
I call it jus, but you call it just.
There's a whole A.P. Herbert story
Yeah,
about somebody pronouncing legal Latin as if it was Latin.
Yes.
Anyway.
Well, whatever I do, I'm sure to get it wrong. So that was, I've nearly concluded my list of what I suggest are linguistic points. I still haven't strayed beyond the text of section 10 yet. The next is to invite the court to stand back and look at section 10.1 as a whole and recall that the right which is granted to the public is granted to the whole of the public equally, without any privilege one way or the other, depending on what particular kind of recreation one subset of the public might enjoy the most. So I suggest one does have to bear in mind and be wary of an interpretation which has the effect, even potentially, of enabling one subset of the public to appropriate parts of the common in a way which goes beyond what is occupied by the space of the individual on the common. It's one thing to be present on the common as a person. The principle of give and take can readily be understood as controlling how different individuals on the commons have to regulate their behaviour as between themselves. But as soon as the individual may not only be present himself or herself, but also erecting a structure on the common, there and then straight away there is an appropriation to that use, which is, I suggest, incompatible with the general right which is conferred on the public.
Are you allowed an informal five-a-side football match?
If you are, and you might be, it's because nothing is erected, and because the activity which
Well, the things are erected.
well, no structure is erected.
Yes, the goals.
Well,
They may be the things that you buy in Argos for about £10.
in that
Fall
case,
over.
in that case, the answer would be no.
Why not?
If you're treating that as a structure,
Just
then
a
no.
structure.
Well, I suggest it wouldn't be, because it could. This is okay. But if you're playing football and you've got goalposts marked out with a pile of clothes one corner, a pile of clothes at the other, that's another way of doing it. That I can see may well be within.
The pile of
What is
clothes is
permissible.
not a structure, but the sort of plastic thing that you buy in Argos is.
Well, I'm not sure that it would be erected on the land. It would be.
Yeah, you have to peg it down because it's windy on Dartmoor.
Well, in that case, your lordship
Or
raises.
take a more. Some people might take a couple of collapsible badminton poles and a net and have a game of badminton.
Your lordship's rightly raised questions at the margins, and of course that's part of the approach in any interpretation question. I accept that. And you can, of course.
You see, Mr. Morshead, I started taking you down this road, and you stopped me because you could see where the road was leading. By starting with a very old-fashioned example of the hobo and going to the modern rambler, and I think you accept that somebody resting and having refreshment, even with the bag they're carrying, is totally unobjectionable. And now we're moving to the further extremes of recreation, which might it be a volleyball or football or any other game that you might play or thing you might do which required some form of equipment. Some of those equipment will be movable and not need to be attached to the ground, and some will need to be attached to the ground. So I was searching when I embarked on this for the line you draw, and I think it is actually anything that could be called a structure, i.e. Mr. Straker's fishing tent that apparently he uses when he's sat by the river and it's raining, which is attached to the ground, I imagine, a little bit like my football goal.
Yes, that's one.
So that's where you really draw the line. It's any structure.
I'm reluctant to draw a firm line, and I'm not sure that it's necessary to do so.
Mm-hmm.
I understand the temptation to sort of cross-question into oblivion an interpretation of the Act. The problem is it doesn't actually work analytically, because Parliament can only deal with the paradigm case. There are bound to be marginal cases. And one can come up with examples like goalposts and ask the question, well, is it a structure that's been erected or not? It's not actually telling you anything very useful about what Section 10.1 has in mind as its paradigm case, and at what point is a use in excess of what was granted, even allowing
But
for the
why
grey area.
should the line not be that you can come on the land, on foot or on horseback, with whatever you can reasonably carry, so long as the things you are carrying are for your personal support or for your recreational purpose. And that might be volleyball, or it might be plastic football goals, or it might be an easel, or it might be anything you enjoy doing. It might be a very heavy bird watching book full of pictures of birds, I've no idea. But surely the thing is all limited by the words open air recreation.
Well, when it's interesting. I mean, when one, as a matter of first impression, asks, tests this interpretation, it's about a 50-50 split. Some people will focus on the open air recreation bit. Others will think, no, one has to start with the question of, well, what is the purpose that people are being allowed onto the commons for? They notice it's on foot and on horseback. So as a matter of first impression, well, with respect, some significance has to be attached to those words, on foot and on horseback. That is not the same as a right to enter the commons and use the commons for the purposes of recreation.
Why does on foot and on horseback not qualify access?
It's, well,
because if you said right of access,
does that imply that a person who enters the commons with a bicycle could, apart from any specific exclusion, suddenly ride the bicycle? Does it imply that somebody who carried on a moped would be entitled?
No, because that's a means of transportation other than a horse or a pair of feet.
But that's, your Lordship's answer tells us that the question is not only to be tested at the moment of entry, but also during the presence.
Yes, so the word access doesn't really mean entry.
It means getting onto the commons.
Well, I'm not sure in this context it does. It's true that to be on the commons, you've got to enter them at some point. But I think the word access in this context means nothing really any different from presence.
Exactly, it means getting onto the commons and having a presence there. That's what it means. This distinction between what happens at the point of entry and thereafter, that's a misreading of the section.
Yeah, I mean, I personally think, I mean, if you ask me just as a matter of first impression, that if you went onto the common carrying your bicycle or carrying one of those fold-up bicycles that people are so fond of, and you carried it for 2 miles, saying, it's my recreation to carry my bicycle on the common, which is perfectly reasonable. It's good exercise, I'm sure.
Yes, and if you then rode it,
and then you decide to travel on it, then the exercise of carrying a heavy weight, recreating by carrying a heavy weight, I'm being half serious, turns into a mode of transportation for access which is not permitted.
well, but again, on the wording of this, I don't wish to descend into a sort of inappropriate for me to rejoin in this way, but then one asks the question, what is it that in the wording of the Act that prevents that?
Well,
But you would be accessing a part of the commons. It happens to be a part a mile from the boundary, but you're still accessing those bits over which you are riding.
You're already on, anyway,
On
I
a
can't
bicycle.
descend into argument.
no, I mean, but it's a very serious point, because what we're all putting to you is really the same point, and that is, why did the judge say that what was the statutory draftsman was only trying to do was to describe the right to roam on the common?
Okay, well,
And if he's right, obviously you win, but if he's not right, then that's a different story, and that's what we're...
let me then show you the material.
Yes.
Because I've told you what it is, let me show you.
Yes.
Could I just ask you one more question? You'll be fed up. You'll be too polite to show it with all this. But you have at an earlier stage, you focused recently on the concept of a structure, but you also said it's of the essence of the right being granted that it's transient or ambulatory. And I ignore the horse for that. On the ambulatory element, a perfectly plausible and not silly explanation is that, situation is that you might think, I want to sit and paint my painting, or maybe even sunbathe, on this spot, which is 10 yards in from the boundary. I have no purpose of walking, not interested in walking at bad legs, but I want to enjoy that part of the commons by painting or sitting on it or having a picnic there. But any walking I do is absolutely de minimis. Yours, if ambulatoriness is the essence of what's being granted, that wouldn't fit, would it?
I'm not, again, I do fear I'm just getting into points of detail rather than principle. My answer is that on one analysis, what's happened there is that there has been an ambulatory access to the commons, an ambulatory use of the commons, with a long pause at the end of it. And there will be an ambulatory.
So the 10 yards you take to the point where you set up your easel is enough to bring you within the essence of the right, even though you then sit there for 3 hours and paint and take a minute to get back.
My argument can well withstand that.
Okay, and I just wanted to test that. Thank you.
Can we look at these reports from 1947?
Beg your pardon?
Can we look at the reports
yes.
from 1947?
And just anticipating the punchline, I mean, if we go to section 60, which follows from these reports, that doesn't say anything about on foot or on horseback. It talks about open air recreation. So you say the open air recreation, as it's used in section 60, means
That likewise means
roaming.
It does mean roaming. It's difficult at this remove in time to plug back into the mindset which prevailed earlier in the century. But nobody was talking about legislating for a right to camp. Let me go to the footpath report.
Sorry, can we not take it to the right to camp for a moment? Is there any indication that the open air recreation was limited to being in motion on foot or on horseback? Leave camping out of it, but is it intended to stop picnicking, painting, sunbathing?
No, probably not.
Just to say, when you come back to it, do you have any explanation for the introduction of the words on foot or on horseback in 1985? It must have been a conscious addition to what was done in 1949.
Yes, the issue was that when the bill was first introduced into Parliament, it made no provision for equestrian use at all. And that was the main reason why it failed first time round. With the 1985 Act, equestrian rights were included, and that is the best explanation I can give for the...
Can we control ourselves a bit on the bench and hear from you about the 1947 reports, because I am very keen to see them.
The footpath report
Yes.
is at volume 3, page 162.
My volume 3 goes from pages 623 to 918.
Oh, okay, yes, I see what's happened. Forgive me.
Hope those who put these bundles together in courts.
834.
See how confusing it can be. 834.
Yes, behind tab 42 if there's a paper volume B. And I suppose it's a negative point, short of reading the whole report, your lordships might wish to satisfy yourselves with this in due course, but camping's not dealt with. I can show you this quite quickly by going to page 895 first of all, where there's quite a detailed index, and you'll see camping doesn't crop up.
Sorry, which page?
895.
895.
And as we'll see, that's by comparison with the Parks report, which I'll show you next, where there's ample reference.
Sorry, I'm way behind. I've got an index here, at page 894. What is that? The footpaths report.
We're now in the footpaths report.
Yeah.
And it's the index at the back of that report. I was just showing your lordships.
Does not include camping.
Doesn't include camping. And that's an accurate reflection of the body of the report. Camping isn't dealt with here because camping wasn't the target. Okay. What the target was, you can develop this at as much length as would be taken by reading the whole thing. The target was roaming, And one sees that most succinctly, for example, at page 838. Foot of the page, a description of the perceived problem, present age need for increased contact with the country. At the bottom of the page, where then can these people roam? End of the page. What was the object at the top of the next page? Fuller use of the countryside through footpaths and access to uncultivated land.
Sorry, where have I found?
That's at the top of
Oh
the
yeah,
next
no, I found it. It's
839,
4 lines down, yeah.
and the next paragraph likewise. In part 2 is the bit that your lordships will be
So
interested
this is about footpaths.
No, your lordship reads
Footpaths
on.
and access.
The lordship reads on in part 2, the second paragraph now on this page. We recommend a comprehensive procedure for opening up large areas of wild and uncultivated land to public access for air and pedestrian exercise, so that all fears of unwitting trespass may be removed. And likewise, the concluding peroration. If your lordships have the time and inclination, it's fascinating to read these reports at length. It's a real, it's stirring to be taken back to this era of innovation and hope, really. And at page 881 in the conclusion, if our proposals are accepted and pass into law, they will confer on the public a precious gift of greater rights and privileges to protect and preserve more simply yet more adequately than in the past the footpaths. That's my Lord the Master of the Rolls' point. They'll provide long-distant footpaths which may be followed for many miles away from the din and danger of busy motor roads. In the wilder parts of the country, our recommendations will provide for the greatest freedom of rambling access consistent with other claims on the land. They will enable active people of all ages to wander harmlessly over moor and mountain, over heath and down, and along cliffs and shores, and to discover for themselves the wild and lonely places and the solace and inspiration they can give to men who have been long in the city.
Only men, I notice. Obviously it wasn't thought that women wanted to exercise.
Possibly not. It is.
It's poetic.
It's a piece of its time. But your lordship has the point.
Yes.
The target is the
Yes.
right. And that is the foundation for section. That is what stimulated section 60, part 5 of the 1949. What stimulated the earlier parts was the report that your lordships find at pages 6, 7, and 9 in this same book. Here, there's ample reference to canting. Just if I show your lordship the index again, if you go to page 811, you can see there are listed differently campsites, camping, camps, holiday, with multiple references.
I don't really understand the point. What are you saying? You're saying that it was this that gave rise. The Parks report was nothing to do with it. Why do you say that?
The Parks report was not to do with, put it another way, the 1949 Act was a response to, among other things, 2 reports.
These two
reports.
Mm.
In sections 1 through to, I think, 58, we find a response to the Parks report. But from section 59, I want to say onwards, that might imply to the end of the Act. I'm not sure that's right, but certainly starting in section 59, we have the response to the Parks report, which I've just shown you. The reason I'm mentioning this is because the appellant has made submissions based on the Parks report, about how you should interpret recreation and so on, but without showing the lordships the relevant report, which is the footpath report, and which is only dealing with the right to roam, as I just shown you.
Okay, but let's look at the Parks report.
So when one looks at the Parks report, the point that I think most struck the judge is that although camping is certainly contemplated as being something that people will want to do in or near a park, the mind frame, the assumption is that camping is a facility that will enhance the recreation. The mindset doesn't understand camping itself to be the recreation. And one sees that, I think the judge found most striking, or probably most striking, the list of activities which starts at page 729. Because at the foot of page 729, we come on to a topic that is close to the submissions we've been hearing from. Sport and recreation. There's perhaps a tendency to regard rambling as the only important recreation in national parks. There must be many who most enjoy wild country, when its beauty forms the setting for other forms of sport and recreation, many whose cherished memories of Exmoor and so on. Without reading every word, your lordship will see that the report lists those activities which were contemplated as being recreation. Walking, rock climbing.
So where are you reading?
If your lordship goes to 731, each of them has its own heading.
Now where's the list?
This is the list, starting at page 731. Walking, rock climbing, motoring, cycling, canoeing and boating, sailing, riding, fishing, the study of natural history, not camping. Okay?
I must say, I love the language.
It is beautiful.
It is marvellous. Particularly the idea that many whose cherished memories of Exmoor, the Lake District, or the Broads are associated with the feel of a keen horse, or a well-balanced trout rod, or the kick of a racing tiller.
The whole report
They led
is
marvellous
poetic,
lives then.
and you don't find that very often these days.
Anyway, right. But this is
That
all about,
struck the judge, but there are
so
additional...
where's the camping bit?
The camping bit is dealt with in several places, and I was going to show your lordships, first of all, paragraph 168, which is at page 723. This is the relevant paragraphs are 168 to 172. I mean, I perhaps could invite the court to read that rather than me reading it out.
Sorry, I must be in the wrong place. Can you just tell me what paragraph 172?
So we're on page 723,
Oh yeah,
paragraph 168 is where it starts.
yeah, you've gone backwards. Yeah.
The lordships see, and this is the point the judge made, this is an example, I'll show you some others, this is an example of how camping was conceived. It was not one of the activities to be done as recreation. It needed control. It was going to need regulation. There were going to be formal sites. There was going to be a formalisation process. It was going to be subject to planning control.
Well, but this is the other. But the other way of looking at it is this is only dealing with camping on sites. So it's,
Yes.
if you're going to have sites, then they've got to be planned and regulated. But that really ignores the phrase, which I don't like, but I agree it's convenient, wild camping.
I think I can accept that, but then one goes to paragraph 201. The lordship may say, well, that's a similar point. But again, what is contemplated is not that the camping is going to be the recreation. It's that it's a form of accommodation that will facilitate people who want to enjoy open-air recreation. Now, you can have the debate about whether that was, in modern English, the most natural way to use the concept of recreation, but that's what people were talking about and thinking of at the time.
Can I just turn it slightly? You're focused on camping not being seen as recreation. And I follow that this report, you say, presages sections 1 to 57 rather than 58 onwards. Can one also say, well, one sees in this example, in this report, examples of what people thought the word recreation connoted? Not limited to walking or riding, but including sport, study of natural history, rock climbing, whatever.
Yes, I suppose so.
And specifically on the phrase open air recreation, if you go through 757 in the bundle, in the conclusion, we believe that we've set out a scheme for the protection of landscape beauty and the encouragement of open air recreation in the wild. And they won't then have had in mind just walking, will they?
No, but your lordship has to be careful when we've described, for another reason, sort of poetic qualities of this language. This is there's an agenda being pushed here. Okay. One has to be on the alert for that as well. But your lordship is right in saying that the concept of open-air recreation wasn't conceived as being... I've shown you a passage which is better for your lordship's purpose. It says expressly.
Yes.
We mustn't think that roaming is the only thing that is of interest to people. I'm accepting that. Before I leave this point, I wanted to show your lordship's paragraph 248 on page 739. The promotion of open air enjoyment. Whereas in national parks, the Commission will have full responsibility for what we've referred to under the general title of management, including development of suitable facilities for popular open air enjoyment. We recommend that and then there's a description of conservation areas. Whilst it's implicit in the title of conservation areas that the protection of their natural beauty and interest should be the first concern, nevertheless, in some of these areas, and parts of them, expansion or improvement of holiday accommodation facilities for open air enjoyment of the countryside will undoubtedly be desirable. We have in mind, in particular, the provision of carefully sited and well-designed hostels and camping grounds of local nature reserves and footpaths of access around them. It just cements the point that whether or not it was the only way to have thought about the subject, the way it was thought about at the time, this camping question, was as a facility that was going to let people cheaply come close to these areas and enjoy them for open air exercise recreation. So well, that is the material that's relevant to the 1949 Act. But to complete my answer, of course, I need to remind your lordships of what was said in Parliament.
Do you mean on this Act?
On the 1985 Act.
Just before you go to the 1985 Act, can we just go back to the 1949 Act?
Yes.
So section 60. Or indeed section 59 first. So 59 says that the Act will have effect for enabling the public to have access for open air recreation to open country. And then section 60 says where an access agreement or order is enforced as respects any land, a person who enters upon land comprised in the agreement or order for the purpose of open air recreation. Now, you pointed out that these provisions aren't directly the product of the main report you were showing us a moment ago, but nevertheless that main report might cast light on what open air recreation is thought to mean at this period. And there's no hint there that open air recreation just means walking or riding.
But that may then indicate why the second part of section 60 is so similar to the second part of section 10.1. The effect is achieved by making clear that all that's authorised is a person.
But I see. So only a person is authorised, but there's no question of it only being on foot or on horseback, or of open air recreation merely connoting a right to roam. It, one would think, would encompass the other sorts of things that were talked about in the main report as recreational and open air recreation.
I'm not sure that I'm not sure I agree with that, because we may end up, if we go down this road, of entering into the CUSAC territory, where we have to recognise that although the same language of recreation is used in different parts of the same act, it's for different reasons. It's not going to be constructive in my respectful submission. It's slightly tea leaf reading.
Slightly what?
Tea leaf reading. That
I still didn't hear.
slightly like reading tea leaves. Slightly
tea leaves,
reading,
sorry.
reading tea leaves. Because in the end, the code that was enacted by Section 60 clearly doesn't include camping.
But can I just stand back from camping for a moment?
Yes.
The question is it limited to roaming, walking or riding? And it isn't, is it?
Well, again, I would suggest that if Section 60 were what we were fundamentally concerned with construing, the question would arise, what was the mischief that this section was intended to address? And the answer to that would be squarely found in the footpaths report. If the equivalent of the appellant were appearing, they'd say, well, never mind that, we've also got to look at the parks report. But my response to that would be no, that's not right. We're in CUSAC territory then. There are different origins for these different provisions. That's a legitimate distinction.
What territory are we saying? CUSAC?
CUSAC, it's in the skeleton argument. The point is simply this. The Supreme Court has deprecated what it calls legislative archaeology.
Sorry, well, I'm very familiar
with the limited exception that sometimes you can see that different origins
Yes, okay, I have the point.
mean that a different meaning is needed, even for the same expression in the same act.
Yeah, fine.
And we might be in that territory. But we're drifting somewhat adrift far from Section 10. Even though Section 60 was the model, the wording is not the same. Section 60 has never been construed. And Section 10 of the 1985 Act has these controlling words. They must be doing something. Access on foot and on horseback. So what is it they're doing? The answer is clearly stated by Mr. Steen in Parliament. Shows what I was going to show your lordships. It's in Hansard, page 902, Horace's Morning. The central words are at page 905. The third paragraph from the top, the second part of the bill.
Who is this speaking?
Mr. Steen.
Mr. Steen.
Aims to give the public a right to walk and ride over the common land. That is clause 10. That is our clause. It sets an important precedent. The 1980 bill gave that right only to walkers. But this bill extends it to horse riders.
Do we, thank you, that's what you told me earlier, and I've seen that, I reminds me, I read that before. We don't have the text of the 1980 bill. Do we infer, however, that the 1980 bill was worded just like like Section 60, i.e. had no reference to on foot. Once you start putting it, you have to put it on horse, you have to put it on foot.
I'll have to check that. I'll have to check that. And the point is explicitly dealt with again halfway down the page when Mr. Steen is explaining the difference between a statutory right and a deemed access agreement. If a walker were confronted by a landowner when walking and so on.
Sorry, where are you? Oh, I see, yes.
It's your
Yes, I have
And then at the foot of the page is reference to another important aspect of this, because the court has rightly been in discussion with the bar as to the package of rights, the overall bargain that was struck. And here Mr. Steen, correctly and accurately, so far as one can tell, is describing the process. The deal was struck. Do your lordships have that 5 lines down? The deal was struck that there would be a statutory right of access for the walkers and the horse riders.
Sorry, no, I haven't got it. 5 lines down in what page?
In the last paragraph on 905. That was the compromise. And then my learned friend showed you...
Just before you do,
Forgive me.
previous line, and the British Hang Gliders Organisation are all adamantly opposed to changes in the access provisions at this late stage. Is that because they think that what they're getting is going to be good enough to allow them to go hang gliding?
No, I don't think so. I would have to check, but my recollection is that hang gliding was not thought to be worthy of expanding, if you like, the rights otherwise granted.
Yep.
In other words, putting another, I don't think one can infer from this that hang gliding was conceived as being automatically within the language conferring rights.
And I think the rest of the text, which you haven't taken us to, but confirms the point which I think I explored with, I forget whether Mr. Honey or Mr. Straker, but the reason why you had to go down the statutory right route rather than simply adopting an access agreement model was that land ownership rights on the commons were just too complicated. You wouldn't know when you were moving from one access agreement to another.
There's too much of a tapestry. So my own friend showed your lordships page 910. That passage halfway down the page about fox hunting. Now, I think the point being made was that, well, fox hunting is a kind of recreation that isn't just riding. May or may not be right, but certainly fox hunting, to the extent lawful.
Where is the bit about fox hunting?
I think it's halfway down. Does your lordship have it just? It's a paragraph.
I'm sad and disappointed.
Just below that, yes, just below that. My honourable friend, the member.
Oh, one hardly dares mention fox.
Yes, that's it. So the only point I wanted to make on that is that, I mean, it's true. I mean, horse riding, so far as lawful, is a relatively long-standing feature, I believe, of Dartmoor. But that's because it's permissive. I'm not sure why one was shown that passage. At the foot of the page...
Just not leaving out all the stuff about the rights and wrongs of fox hunting. In 1985, when it was perfectly lawful, this would actually give a right, irrespective of any customary or permissive rights, this would actually give a right to enter in pursuit of a fox.
It may well do.
Yeah.
It may well do. At the foot of the page, though, I just wanted to make this point. You were shown this by Mr. Straker. My point is to emphasise the extent to which Mr. Steen was involved in the process of the legislation.
But he wasn't the promoter.
I'm going to come back to that. But at this point, Your Lordship, see at the bottom, the bill represents the best possible overall compromise. So that again is being acknowledged. But then at page 912, you see Mr. Steen offering an amendment. Somebody objected to overzealous penalisation, it seems. Mr. Steen offered an amendment.
Well, he's a member of Parliament.
But that offering the amendment is consistent with our basic position, which is that Mr. Steen was the mouthpiece for the promoter in the House of Commons, on the floor of the House of Commons. That's what he says. When one's I'll come back to the Pepper and Heart in a moment, because there's a passage I'd like to show you in it.
But one doesn't get much.
we've got this fascinating debate about whether someone's a promoter or not, and therefore whether that makes a difference to whether pepper and heart applies. But you don't get that much out of Mr. Steen anyway, do you?
Well,
He doesn't say anything about camping either way. Have I forgotten something?
Well, if I to limit on how far I can take the point, our point is simply this: we say that he has described fully what Section 10 does and what it was intended to do. He's saying that the meaning of Section 10, it aims, this is his language, to give the public a right to walk and ride over the common land.
But he doesn't say what it certainly does say about recreation. Well, this comes back to what we've been
I'm not
saying
sure
for the last
because
hour.
I'm not sure because if it were the case that the second part of the bill aims to give the public a right to walk and ride over the common land and use it for any other recreational purpose, including camping, that is a completely different thing from what has been described to the House of Commons. Nobody listening to that speech would think that Parliament was being asked to confer on the public anything other than the right to walk and ride over the common land.
Well, so what?
Sorry.
I mean,
Because
what they say, I mean, it bemuses us all to read what they say in the Houses of Parliament. But what we have to construe is the legislation.
Well, exactly so, and that's why.
Your real problem is, it's like, in a sense, your better point is a point of, if anything, about mischief. It's not pepper and heart. You've got another completely different problem about pepper and heart. Pepper and heart, they've really got to address the very point, which is in issue, namely, does it include a right to camp, and say, no, it doesn't. But if it doesn't say that, it doesn't help you.
In my submission, that is the point being addressed by Mr. Steen. He is saying exactly what Section 10 includes.
He doesn't mention camping, which is the point we're concerned with here.
I mean, those in Parliament will not have thought, oh, Mr. Steen is saying you can't picnic.
They will have understood him to have meant what he said. It's a right to walk and ride.
And therefore not a right to picnic.
The members of Parliament listening to that speech will probably not have thought along the lines of, well, does that foreclose a right to stop and have a picnic? They would have understood walking and riding. And if they'd gone on to ask the question, they would have reached the conclusion that we've reached. That will include such things as pausing to eat and refresh oneself.
But if you're accepting that picnicking is all right, you can't say that Mr. Steen was stating comprehensively all the things that could be done.
He hasn't construed the extent to which ancillary rights might be implied. But he has described the paradigm case.
Well, it's probably all you can get out of that.
And I wanted to, I mean, while I'm on this point, I'm well out of sequence from but I wanted to, if I might, just refresh the court about the rationale for that. There's no perhaps need to turn it up, but it's in the volume of authorities at page 220.
Well, I will if you're later.
Because Lord Brown Wilkinson sees the admission of these statements as part of the mischief, the process of identifying the statute mischief. So,
Well, he distinguishes between the mischief and the legislative intention lying behind the ambiguous or obscure words.
and then when one goes over the page to 221, your Lordship sees that there's a realision between those 2 points. Between letters D and E on internal page 635, if that's more helpful.
Thank
between B to E. But the point I wanted to emphasise most was the rationale which is stated at internal page 634 F to G. It's an inescapable fact that despite all the care taken in passing legislation, some statutory provisions, when applied to the circumstances under consideration in any specific case, are found to be ambiguous. One of the reasons for such ambiguity is that the members of the legislature, in enacting the statutory provision, may have been told what result those words are intended to achieve. That is precisely our case. Parliament was told explicitly, it could not be clearer, what result Section 10 was intended to achieve. It is the exemplar of the rationale for having admitted Hansard material in the first place. And that helps also to shed light on such questions as arise from the submissions that we've heard this morning. Well, why doesn't Section 10 explicitly exclude camping and such like? There was no need to. It had never entered anyone's head that there was a need to do any such thing.
Well, I mean, you say that, but Section 193, back in 1925, talked about access for air and exercise, which is, on any analysis, a narrow description. And they thought it right to exclude camping.
They did. And I've dealt with this in the skeleton, at paragraph 65 through 68. And there are at least 5 reasons, as your Lordship will remember,
Yes.
paragraph 67, for making express provision against camping. And think of at least 5. I've listed there. One which is specific to section 193 is explained by Mr. Craddock in his paragraph 46, which is that there was an old-fashioned concern about camping by gypsies. Where there's any open piece of land, there is what at the time would have been regarded as a risk of gypsies camping on it. So when one finds an express prohibition against camping, that is part of the sensitivity. It's not because anyone thinks that the public is getting a right expressed in a way which would include camping. It's deferring to the obvious factual truth of the situation that a piece of open land is going to attract people.
I mean,
who will want to camp on it.
You say all this, but you know, you can see the time from 1931C. It was an area, a time when motor vehicles were not widely used by individuals, and horses were used to draw things onto the land. And the wording is, such right of access shall not include any right to draw or drive upon the land a carriage, cart, caravan, truck, or other vehicle, or to camp or light any fire.
Yes. So
that was an extremely concise way of dealing with all the things that we now deal with at much greater length. But
your Lordship is right. Of course, this is the first interpretation case where one ends up asking, why wasn't it made clearer? Okay. And it's not the first interpretation case where people are able to show the court examples of other bits of drafting where explicit provision has been made, where it's that much clearer.
It's just that you say it never entered anybody's head, and I find that really strange because it was obviously a thing for years, and they're looking at the 1947 report, and the 1947 report, the second one on parks, is replete with stuff about camping, not wild camping, an expression I deprecate, but formal camping in structures in a camping site is what that parks report is really about.
Another way to make the point evidentially about how people were thinking about have put this in the skeleton argument as well, is to remind the court about the process through Parliament of the 1949 Act, including the interesting petition of the caravans. This is a document which is in the bundle.
Yes.
It might be helpful to just to remind your lordships of it. I think it went into the supplementary. So the supplementary bundle, page 2. Sorry, I meant to start at page 3.
The Great Petition.
Yes, of the caravans.
Bit difficult to,
But the point is only this: if your lordship's question is directed to what did people understand was going to be done by what became the 1985 Act, the caravans did not understand that they would have a right to camp. Their complaint was that the Parks Authority wanted to take a rule-making power which they thought was going to prevent them from camping even where they had landowners' consent. That was the campers put in the light petition, we put in the caravans.
where's the guts of it?
The guts of it is paras 8 to 9. And the judge dealt with this in the judge would examine this and other material on this topic.
Which paragraph?
In the judgment, paragraph 43. And additionally,
Sorry, 43.
43 and 44, and additionally, moving away from the petition, the judge recorded the report of the Select Committee on the 1980 bill, paragraph 69. Camping and caravan clubs asked the Select Committee to delete the Park Authority's bylaw-making powers to control camping on common land. While the backpack camper causes no problems, those in caravans, dormitories and highly coloured frame tents do. The Park Authority have actively encouraged the opening of new sites, sometimes in cooperation with the camping organisation. There are now sufficient sites in and around the National Park to meet the demand, and there is no need for casual camping by the roadside or on open common land. Such camping spoils the enjoyment of the open landscape gardens, gives rise to a risk of disease in commons animals and injury from certain types of litter. The committee make no amendment. One can't just put this sort of point to one side. Parliament was being told that people were going to get a right to walk and ride on the commons. That was the bargain that had been struck, and which balanced fairly the interests of the landowners, the commoners, and the public.
I'm afraid I haven't looked at this properly. Can I just understand it? So it starts
Sorry,
by...
can I have the reference again? I put it away. Where we...
I've just read paragraph 69 of the judgment.
Of the judgment.
The quotation opens by saying the camping and caravan clubs asked the Select Committee to delete the Park Authority's bylaw-making powers to control camping. And then it ends up saying the committee made no amendment. So on the face of it, they're declining to amend to delete the power to control camping. Is that what is happening?
That's right.
Well, that implies that as it stood, there is power to control camping by bylaw.
By bylaw, there is, and I've accepted this, there is power on the part of the Parks Authority to regulate camping. This is a problem with, I'm afraid, the way the argument is developed. We're all over the place now. It's covered in the skeleton argument. The bylaw-making power, step back. The Act, in its preamble and in its recitals, enumerates a number of purposes. One purpose was to regulate public access to the commons. Another purpose was to confer a right of access. The bylaws achieve the first. Whether or not what they regulate is otherwise authorised, and you see that by several examples in the bylaws, as my Lord the Master of the Rolls pointed out this morning. So the bylaws are made pursuant to that part of the Act's objective, which is to regulate. But the bargain that was struck in relation to access is, as I've now described it, ad nauseam. And this branched off from my answer to my Lord the Master of the Rolls' question about no one was thinking about this. I'm not exaggerating when I say that. It was not in the minds of anyone involved in the legislative process that camping might be within what the public would have a right to do when this Act came into force. It wasn't anywhere on the horizon. The draftsman had no inkling that he needed to make express separate provision for it. He was entitled to take the view that the form...
Wouldn't that be right? We know that regularly, long before this Act came in, the Peak District National Park Authority, this is Mr. Craddock's report, was always in its standard form excluding a right to camp without the owner's consent. This is back in the 70s.
What Mr. Craddock's report...
Where do we find it?
If you look at page 101 in the supplementary bundle, you find his schedule, which is an annex, strictly speaking, which is referred to at paragraph 71, so that's page 79. What goes there first? Page 79. 71, I reviewed 51 such agreements and orders provided by Natural England and a summary at Annex C.
I'm sorry, but
and then if you look at, if I just make the point, a lot of them, particularly the first page or two, don't refer to camping. But from item 14 on page 102 onwards, the definition of open air recreation in the access agreements standardly say it doesn't include camping without consent.
Yes.
And I've just skim read through all these, roughly the same language. These all seems to be one from the Peak District National Park. Actually, that's what Peak Park JPB means. But I'm simply meeting your point that you're saying nobody even thought that...
Saying nobody in the legislative process that led to the 1985 Act thought that there was a need to make express provision for this. It wasn't
well, the DNPA...
agenda.
I see. But you would have thought the Dartmoor National Parks Authority would know what other national parks were doing.
I'm not sure, but even if that's right, I've made my submissions on the access agreements and my skeleton. Paragraph 75 and 76. The short point is that when you look at them as a whole, there's no consensus about what is meant by open air recreation. The technique that's used, that your Lordship has drawn attention to, it could have gone one of two ways. You could have had an access agreement which said access for camping is not allowed. That's just taken out. But the technique which has been chosen, at least in that example, is to define what is meant by open air recreation.
I see that entirely. I'm sorry, I wasn't really taking a view on your point that this is positively helps them. I was merely picking you up on what I understood to be the suggestion that nobody in 1985 could have thought that there was any need to restrict wild camping. And that seemed to be surprising when at least one prominent National Parks Authority regularly does so.
I've shown your Lordship the material, which makes, I suggest, but that's the material I rely on for the position, but my submission was narrower than perhaps your Lordship had understood. My submission is that nobody involved in the legislative process, so far as the evidence shows, thought, I'm repeating myself, Nobody
Okay.
involved in the legislative process had that expectation.
But of course you'd accept that even if that was so, that's not in any way conclusive. It's very common that Parliament uses general language without thinking through all the consequences.
That is
All
sometimes
possible
the case,
applications.
and that it's in those situations where the mischief rule sometimes has a part to play, and where pepper and heart sometimes has a part to play. Especially in a case like this, where private rights are being interfered with on the back of a bargain which was struck, which was limited to walking and riding. So there must be a limit on how far beyond that paradigm case the court should be willing to go. And we say wherever you draw that line, it is before you get as far as erecting tents. It can't have been in contemplation of Parliament that people with a right to go onto the commons should be allowed to erect structures such as tents. May I just check my roadmap?
Don't stop on the way because you might be in danger of unlawful wild camping.
I'm not going to be putting anything up. Right, well, I think, let's check, that I probably said as much and more than once as I need to about my first proposition, except I'd like to just, so that you have a note in one place of what we say about section 10.1, there are just 3 points. First, there is no basis in the language of section 10.1 for suggesting that it sanctions tents or other structures on the commons. Secondly, on the contrary, the language shows a consistent assumption that no thing, no activity is sanctioned on the commons beyond the presence on that land of a person and his or her horse for the purpose of recreation, and what is incidental in the R. Black case for those purposes. And thirdly, treating the right of access as if it included a right to erect a tent or other structure would in truth give something to one section of the public at the expense not only of the landowner, but also at the expense of the rest of the public. On the statutory mischief point, I've shown your lordships the material that's relevant to that. The references in my skeleton argument are at paragraphs 54 to 61. We say that takes me to the end of my first proposition. The second is that even if I'm wrong in showing that section 10.1 clearly has the meaning we say, then at the least there is uncertainty as to whether section 10.1 conferred a public right to erect tents. See my skeleton paragraph 13. And in that event, the appeal should still be dismissed for the 3 reasons I gave. The first is the principle of interpretation against expropriation. And my lords, that's in my skeleton starting at paragraph 37. And I just make...
Just give me the 3 points. The principle of expropriation. The second one is...
The principle of interpretation of a private act against the promoter.
Oh, yes, yes.
And the third was pepper and heart.
Yeah, sorry. Yeah.
The principle of expropriation is not challenged by the appellant or the Open Space Society on the basis that it has no continuing currency. It's not said, for example, that it's been superseded by more general statements of the law. What is said is that the owner's rights in our case were not interfered with enough to attract the principle.
Well, it seems to me that the principle is a sound one. And on one analysis, it doesn't really matter how small the interference is. It's something the court has to take into account. But if the court formed the view that the words clearly meant X, and that was expropriatory, they're a statute, and the statute can expropriate. Normally, a statute will not expropriate without compensation, and there's plenty of authority about that. But this is not really a case. There is some talk of compensation in those reports, by the way.
Well, that's right.
So that makes your point that it is prima facie expropriatory. But where does it really get us if we reach a clear conclusion on the
if you're of the view that the wording, contrary to the view of the Chancellor, has a clear meaning,
yes,
it's exactly the opposite of what he said, then
yes,
of course I don't get as far as...
which only goes to show how these things are, these points of construction are so difficult.
But if your lordships don't get as far as that, then you have to ask, well, has Parliament used clear language to effect the expropriation? That's what, when one speaks of taking a strict construction, that's what one means. Parliament has to...
Well, to interfere with property rights. I mean, you're absolutely right. I think, anyway, speaking only for myself, that pitching a tent and sleeping in it overnight excludes the owner from access to that part of the ground, if it's a right, and is in some way reducing that owner's property rights.
My lord, yes, but adjectivally...
But I mean, it is modest.
Well, no, adjectivally to that, it is substantial.
Sorry?
It's not just a modest expropriation. When people camp, there comes with the erection of the tent problems. Maybe in the past less so, but these days there come problems, and this was the subject of evidence.
Well, brightly coloured tents, I noticed, were complained about.
They were the subject of complaint back in the 1980s, but these days the problem is more substantial. May I give your lordships the references to the evidence? Mr. Darwall's second statement.
But what give us the references?
Paragraph 7.2, page 40 in the supplemental bundle.
Mm-hmm.
Mr. Howell's first statement, paragraphs 9 to 14, pages 8 to 10 in the supplementary bundle, and his photographs at pages 26 to 27 of the aftermath of one example.
Is this about littering and things like that?
Littering, the spoliation, what's the word? The damage done to the ground from the fire that had been lit, the need to remediate the land, which is damaged in this way, and a stray tent.
But of course, this is banned by Schedule 2.
Well, Lord, one has to deal with the reality. It's no good having a right to claim in trespass after somebody has left the land. What use is that to my clients? They need to know that people who are erecting tents can be stopped from doing that before they've lit the fire, left the rubbish, done all the things they're not allowed to do, and which are trespasses. Okay? We have to deal with this at the level of what is pragmatic. And the effect of being able to come onto land and erect a tent is inevitably that the landowner is the one who clears up the mess, including, and it wasn't a spectral point that I was raising earlier, a tent being left for someone else to occupy, that is exactly what is illustrated by one of these photographs.
Well, the photos are quite shocking, so you don't need to persuade me of that. Yeah.
So certainly there is expropriation. And I've emphasised that point slightly heatedly because there's a certain section of the public that thinks this is just the landowner making a fuss, throwing his weight around. It's not that at all. If you're a responsible person with the privilege and responsibility of managing land, these things matter. Also, Mr. Howell's second statement in the supplementary bundle at page 161, paragraphs 3 through to 10, dealing with the agreement which has been reached since the Chancellor's decision, which includes payment of a fee to each landowner, and paragraphs 11 through to 13, where he says some more about the effects. So I respectfully suggest that the principle of interpretation against expropriation is very strongly engaged by the facts of this case. Then there is the principle of construction against the promoter. Well, that too is engaged by the facts of this case. It's a similar rationale. The rationale is essentially the same. It's that the promoter needs to use clear language in order to get what he later says he wanted. I haven't really heard much about that. And then we come to Pepper and Hart, which is in the skeleton at paragraphs 45 through to 53. I take that as read. I've probably exhausted orally what
I think we've done Pepper.
I think I've done Pepper and Hart. I was about to say to death, but I won't say it. Then my third point is that iteratively, the points I've just made, the Pepper and Hart material is itself admissible to show at the least that it is uncertain whether Section 10 includes a public right to erect tents. I'm not sure if that's controversial or not. It's my understanding of where the law has reached in view of the latest summaries of it in the Supreme Court, that there is this sort of bootstrap situation where the background material can itself demonstrate that there's an ambiguity in the legislation. I think I'm correctly summarising where the law has got us on that. My fourth proposition is that on a correct basis, the matters relied on by the appellant and the OSS are consistent with or positively support our interpretation. I may have to take this as read, but the paragraph references in the skeleton are 22 through to 36 and 62 through to 97.
Well, that's most of it.
I know. It shows how much secondary material has been used by, really not by me. Okay. I think I ought to say something. Do I need to say something about the bylaws? I think I have made my submission about the bylaws, which is that the bylaws are criminalising conduct which is to be prescribed, whether or not that conduct would otherwise be within the right of access to
Well,
the commons.
that's true, but Mr. Straker gave me what seemed to me to be a satisfactory answer to that the effect of the introductory words of Section 10.1 was to remove the right conferred by Section 10.1 where it had been prohibited by bylaws. Do you accept that is the effect?
Yes, it has that sort of interchanging effect, but that doesn't, I suggest, negate the point I'm making. That doesn't stop the reason why the bylaws are made from being in order to criminalise what would otherwise be... It's indifferent to whether what it prohibits would otherwise be permitted by Section 10. That's
Oh, I
separate
see.
from the point Mr. Straker was making
Yes,
to
I
the
see.
Lordship.
Well, I mean, the bylaws are relied on in various different ways. That's the most analytical way of relying on the bylaws, I suppose, is to say that these things would not be excluded by the bylaws if they would not otherwise be included. Can I ask a more general question about the bylaws?
Yes.
Looking, as it were, at the background policy of all this, the problems caused by wild camping could be resolved by a bylaw prohibiting it without the landlord's consent, the owner's consent, I should say, and or in certain places. Maybe the whole of the commons or parts of the commons, where it's thought to be particularly problematic. That would be a reasonable way to strike the balance, would it not? Or at any rate, it's suggested by Mr. Honey that it would.
Well, that in the end is the question that your Lordships have to decide. Is that the balance that the Act has struck?
I see that, but
It's-
if I thought it very unlikely, if I thought it was very unlikely that Parliament could have intended such a thing, because it would be a completely unreasonable balance, that if the construction is up for grabs, that might influence me against concluding in favour of such a construction.
I mean,
On the other hand, if it's a perfectly reasonable way of striking the balance, it might go the other way. That's why I wanted to raise it with you.
I understand. I don't accept that it would be... I'm not sure I can go so far as to say it would produce an absurdity. But when one stands back and reflects on what I've shown your Lordships about the mischief to which Section 10 was directed, and what the landowners were told, Parliament was told at the time about the bargain that had been struck, it's not reasonable to expect the landowners to give up without compensation their right to control camping on the land. It's not a reasonable, it's not a trivial extension of the right which was explicitly conferred using clear words. It's not a small thing to add camping. So I can't say that it creates an absurdity, but I do, using your Lordship's language, reasonable, I do say it would be an unreasonable extension compared with what Section 10 appears to contemplate.
Are you in a better position now than you were this morning to tell us actually whether what caused the current issue to be raised was that the landowners were asking for such a bylaw and the authority was refusing to make it?
So far as we can establish, I think there's a link we can send the court. The draft bylaws have renumbered slightly. I think it's now bylaw 7. There's no relevant change proposed. The immediate trigger, as I understand it, was that the Parks Authority would not add Stall Moor to that list of places.
They wouldn't
add Stall Moor, which is the name of my
Stall Moor.
S-T-A-L-L.
Right, okay, yeah.
Stall Moor.
Yes, I see.
To the list of areas where camping.
So that's one of the things. It wouldn't apply to all the landowners affected, but your particular client, Mr. Darwall, was effectively asking for wild camping to be banned on his land or the relevant part of his land, and they wouldn't do it.
Even that is a slight oversimplification. I mean, my client has, of course, been painted as sensitive to this. He's been painted as somebody who's hostile to camping and all the rest. That's not it at all.
No, that was
There
not
are
the
particular
implication behind my
bits.
question either.
No, but there are particular bits of his property where this is a real problem.
Yes.
He wanted to get those
We've probably seen the pictures.
taken out as being places where you could... And the
Yeah.
park just wouldn't listen. They just weren't interested at all, speaking candidly. So if you're asking, who's the bad guy in this piece, it's not my client. But that's the nuance that I do need in
No,
fairness
but I mean,
to my client.
We never had bad guys in this court.
Not on this side.
But it's part of the background. It's no more than background, inevitably. It's a single illustration of how the kind of problems which have given rise to all this could in principle be met, namely by doing exactly what your client wanted to happen, But the problem that it's not within his control, and if they say no, he's stuck.
That is exactly it. That is exactly what has happened.
Okay, well that is helpful.
There's one piece of homework that I really do want the answer to, and that's the one I asked Mr. Straker about before lunch, and that is the pre-existing bylaw or bylaws under the 1949 Act, when this legislation was going through Parliament, because it seems to me very significant to look at the bylaws that were in the contemplation of the legislators.
And I'm sorry to say that hadn't even occurred to certainly to me. So I don't know what we'll be able to do on that, but I'm sure notice will be taken.
Well, I hope you'll both make, all three of you will make some efforts to find out, because it seems to me something that could be said to be in the minds of the legislator.
The next chunk in my fourth point starts at my skeleton paragraph 62, carries on to 97. I've dealt with quite a lot of this. I've referred your lordships obliquely at all events to CUSAC. There's reference also to the Southwark and TfL case. I wanted to show your lordships what Lord Bridge said in TfL, if I may. This isn't too indulgent in the use of time. At page 609 in the authorities bundle.
We must give Mr. Straker an opportunity to reply.
Yes.
609.
Yes.
I've got Lord Briggs, 609.
Oh, I haven't done a bad reference again. 609 in the authorities bundle. It should be Southwark LBC and Transport for London.
Yes, but you said you wanted...
Lord Briggs, did I not?
Oh, you did say Lord Briggs. Okay, fine. Yep, I want that.
He summarises the relevant principles. He refers to CUSAC next to letter F, and I just wanted to remind the court of what he said in paragraph 5. Lord Wilberforce's wise words have lost none of their force in an era which has seen an exponential increase in the complexity of legislation. It's hard enough on the law-abiding public that legislation is often unintelligible without the assistance of skilled lawyers. It's even worse if its meaning requires in addition the assistance of a legal historian. And then nonetheless, there are some exceptional cases where what Lord Newberg called legislative archaeology is necessary. I make the point that that is quite a high hurdle, and by contrast with our case, I make 4 points, if I may. First, there is only one statutory model, which is section 60 of the 1949 Act, which we've looked at. Secondly, section 60 of the 1949 Act has itself not been interpreted judicially. Thirdly, it is clear, I say, based on the access agreements, that there is no consensus about its meaning.
No consensus about the meaning of what?
What section 60 does. Does it do more than authorise a right to rent?
Mm.
And fourthly, in any event, the wording is different and in a respect which is material. Access on foot and on horseback. Words of control and limitation which are missing from section 60. Back to the skeleton, I've dealt with section 193, which I cover at 65 to 68. Looking down to paragraph 69, I think I've made my submissions about the 1949 Act. Same also down to paragraph 74, the reports. Access agreements, I've made my submissions about those. There they are again, set out in writing. And then Mr. Craddock's other 48 statutes. There are some remarkable features of Mr. Craddock's evidence which I called attention to in this paragraph, and which with all possible respect are more significant by a considerable margin on the submissions on the back of them made on behalf of the OSS. The first point is in paragraph 81. I'm not sure really, well, I'm sure we're nowhere near the area where this kind of legislative archaeology is appropriate. I've said excavating Thebes will not reveal the foundations of Troy. That's what's been attempted by Mr. Craddock.
That's your own coinage, Mr. Moore says.
Yes. The next one is that despite his obviously exhaustive researches, Mr. Craddock has not been able to show that there exists any judicial determination that any of these rights or any other right has ever been construed as extending to camping. And against a backdrop going back 150 years, that is pretty striking, in my respectful submission. And neither has he been able to identify any evidence at any time of anyone ever having camped anywhere in purported pursuance of any of the statutory rights to which he has referred, which also speaks volumes. I'm going to develop that in a moment.
Well, what were the people doing on your client's land when he took those pictures?
Exactly. I should say, beyond trespass. I'm
Right.
sure there are examples of people. Actually, no. So strictly speaking, my lord, even those people, because what the evidence showed before the judge was not that there were people who had camped on Dartmoor in pursuance of the statutory right. That was not the evidence. May be surprising to people listening to this, but that was not the evidence before the judge, and it's not the evidence before this court either. It's not. The submission has got ahead of the evidence. In paragraphs 84 to 85, we've dealt with the fact that there are various reasons why camping might be expressly excluded. In paragraphs 86 to 87, I make the point, looking at the legislative history overall, there's no basis in historical precedent for any member of the public to expect that a grant of public access to land will include a right to erect a tent on. And contemporary exposition supports our case, we say. It's not credible that the 1985 Act should have departed from that consistent pattern without attracting at least some comment at the time, and yet nothing has been produced to suggest there was any reaction to this stunning new right. A correct analysis is that there's no evidence of it occurring to anyone at the time that a new public right of camping had arisen, and that is powerful evidence of a contemporary understanding that the 1985 Act had not removed the requirement of landowners' consent. The later statutes, these are strictly speaking irrelevant. It's a short point. If your lordships wanted authority for it, it's in the Southwark case. I've given you the reference in paragraph 90. And the overall conclusions in paragraphs 94 to 97, I do rely on strongly. The telling point to be noted from the later statutes is not what they reveal in point of detailed interpretation, 2000 Act or anything like that, compared with section 10.1. But what they indicate when viewed as part of the overall history of Parliament's interventions in this field. And I noticed that what was said by junior counsel for the OSS in reference to section 15 of the 2000 Act is consistent with this. If you're going to look at this as a package, there are consequences which flow, and they're adverse to the appellants. Because throughout the whole history of Parliament's interventions in this field, right up to and including 2000, there is no precedent for camping being included in what the public might do under the rubric of access to or recreation on commons or other access land. And there have been different drafting techniques to achieve that effect, with different degrees of clarity and explicitness. But even after the 1985 Act, it remains the case that there is no precedent in cognate spheres of legislative intervention of Parliament conferring a right of camping on the public. And so if it turns out that Section 10 gave the public a right of camping on Dartmoor, then this was A, contrary to the ordinary grammatical meaning of the language used, or alternatively contrary to an available meaning of the language, B, unprecedented at the time, C, unasked for. D, contrary to what the promoter told Parliament it was asking for. E, unnoticed at the time, despite close scrutiny of the very issue of capping during the legislative process. And F, to this day, unique in the sphere of legislation. And for an act which is disproprietary, as well as being private, to receive that effect, despite being at least capable of having the more limited effect for which we contend, would defy the interpretative principles applicable to those kinds of legislation, be groundbreaking and not in a good way. And that is my fourth point in my roadmap. And fifthly, iteratively with two above alternatively, and in any event, the matters relied on don't demonstrate the clear meaning. Section 10 includes a right of the public to erect tents on the commons, and they don't outweigh the considerations above with the same result for appeals. Although I think I'll have to take as read the rest of the skeleton argument. I have covered the points in my skeleton argument, albeit in a different order, which is why the roadmap might be helpful later. But I haven't departed from it.
Just got one small point. I think I confused matters this morning by saying that there was evidence about the content of access agreements on Dartmoor, because I was thinking of the evidence of Mr. Craddock, which wasn't about Dartmoor at all. Is there any evidence about access agreements, what access agreements say about camping on those parts of Dartmoor which are covered by access agreements?
We haven't looked into that, no.
No, okay, the answer is there is no evidence. Just wanted to be clear about that. Thank you.
Forgive me, I've been handed. Yes, on one matter, your Lordship's asked about what was the text of the precursor bill.
Yes, I can.
And I'm told it was relevant, it was this: the public shall have a right of access to the commons on foot for the purpose of open air recreation.
Yes, obviously, because that's why they added the horse.
Indeed, but on foot.
I wonder whether it even said on foot.
Exactly, I thought that might be the reason for you asking the question, because that is...
If it had been like the section 60, it wouldn't have had even on foot.
Exactly so. So even in its original form, those words were doing something. Unless I can help, I about to say unless I can help you.
Thank
That's
you
an
very
exaggeration.
Mr. Moore's much appreciated. Mr. Straker.
I'll take 4:15 as the cut-off point, if I may, my lord.
Well, we'll sit, an extra 5 minutes if you need it. But,
Thank you. Well, I shall try not to. First, a matter which was left over from this morning, which was there a gap between 1985 and 1989 in terms of bylaws having been made? There was such a gap. The first set of bylaws were 1989. They were amended in 1996, and a series of amendments was put forward which led to the prompt for this litigation as discussed, because whilst some land was being removed from the possibility for camping, it wasn't the land that my learned friends' clients were interested in. As far as the question of Hansard is concerned, may I draw your attention to two things. First, that there is no reference at all to any form of discussion of the language with which we are concerned. And second, and you will see this in page 916, I believe it to be, of the bundle, that it was made perfectly plain by one member in responding to the person who had introduced the bill, that what was concerning was the problem of management and the problem of recreation and access. We cannot have one without the other. And further, it had been earlier said in the debate that some form of control was needed because of the vast number of tourists who were using Dartmoor. So I say that Hansard doesn't help us at all, and we are left with the words which my learned friend says on analysis carry the meaning for which he contends, I respectfully say for the reasons advanced this morning and for the plain language of those words, that's clearly not so. And when one looks at 10 and one looks at the break in 10 after the semicolon, it's perfectly obvious why the draftsman spoke first of entering into without breaking, because he was contemplating how you actually got in, and then he's looking at the circumstance of someone being there. And so we are left with, on that basis, the exercise in terms of open air recreation. And my learned friend's argument really boils down to the proposition that open air recreation cannot include any form of camping. And please note, my lords, that the claim as pursued by my learned friend, see page 64 of the core bundle, and the declaration and the judgment of the judge as given, page 55 of the bundle, extend beyond merely putting up, however too bit a tent it might be, extend beyond that, and would cover, although this language is not used, my lord the Master of the Rolls is hobo who goes on, or anybody, whether he's from Australia, waltzing Matilda or otherwise, with his jolly swag bag to keep him company for the night. And can I make an incidental observation here?
So just to be clear, I understood Mr. Morshead to limit himself to structures and erection of tents. And if you look at the Chancellor's order, he says it does not confer on the public any right to pitch tents or otherwise make camp overnight.
Yes.
So that includes the person who goes out with a small rucksack and lies down bivouacking without a tent.
Absolutely.
But sleeps.
And that was how the claim was put, see page 64.
Right.
And so that would cut out...
So you say it also, it actually limited to overnight. So if you lie down and rest in the daytime and sleep for 8 hours, you're okay. But if it's overnight, you're not.
Well, yes.
Where does it say that in the legislation?
Well, it doesn't say that in the legislation. And my learned friend says sleep makes all the difference, as if when one has gone out for the purpose of...
But he says sleep's not a recreation. Do you disagree with that?
A recreation can embrace sleep. For instance, the recreation of taking 16 hours on Dartmoor to include sleeping overnight so that one can observe the sunset in the evening and the sunrise in the morning. But it's, with the greatest respect, not a sensible proposition to say that sleep takes one outside the scope of recreation. What happens, if I may respectfully inquire rhetorically, to the artist who is sitting there, but rather overcome by the sun or whatever it is, simply nods off for several hours.
Or by the submissions?
I've encountered that very problem, my lord, both receiving and giving. So one is conscious of that circumstance, but one would still say, I would hope one would still say, that in that circumstance one's still operating either judicially or operating from the bar. The fact is that one has to recognise, my own friend says, puts it in this term, reality of the matter, and that is so. A recreation can embrace a circumstance when somebody might be sleeping.
Well, overnight may make a difference, but suppose your intention were to go out with a rug, walk for an hour, lie down, read a book for a bit, and always say, and I will then have a snooze, however long it takes, an hour or two, then I'll wake up and walk home. Is that purposes of outdoor recreation? The whole thing?
Certainly.
So it's not just written nodding off when the audio is too boring, it's actually part of the idea to have an
Yeah,
argument.
absolutely. Just as whether you take a view of a suburban garden where you can observe that every day, or take a broader perspective, that is happening,
Yes, no,
and it's
no.
recreation. We're left essentially, when one drills down, to the argument that something is being appropriated here, and I completely endorse the proposition that one construes to avoid that if one can, but if one's left with the circumstance of the plain meaning, one gets there, and the relevant cases for this are behind, and I shan't take your lordships there now, but your lordships will see it's Cadogan, tab 16, and that was pre the Human Rights Act, and Oxfordshire County Council 21, which was post the Human Rights Act.
And Oxfordshire County Council is a village green case.
That's right, and it was said this is not something which is an appropriation of property, and so that plainly, analogously, would operate here. So the other matter I just wanted to mention, if I may, is could your lordships kindly note paragraph 29 of our skeleton, and then my learned friend spent a long time looking at the report about footpaths or paths. If you look at the introduction to that, page 837, it makes plain that part of the exercise was access to open space for recreational purposes. And that's page 837 in the forward. And in any event, whatever that says, it doesn't, of course, address the problem with which your lordships have to confront, namely, what do these words actually mean? And my lord, I've arrived at 4:15, and unless I'm reminded of anything dramatic, I can pause, I can stop there.
Anything dramatic? Thank you very much.
Thank you.
Well, can we thank all council and also